I am living flesh and blood, human. Government has taken that name and made an all caps name. So it will go to the Supreme Court, I promise you.
You understand that you've been charged in this case with cocaine, heroin, or another narcotic. The maximum penalty for that offense is up to 4 years in prison.
No matter what you do to me, I will get out of it, and there will be lawsuits.
A man who identifies himself as a sovereign citizen appeared in court recently, and the situation quickly turned tense. He stood before a very strict judge and began claiming that he is not a legal person under the law. He insisted that normal rules and laws do not apply to him, as if he lives under a completely different system. His statements created a heated moment inside the courtroom as the judge listened carefully to the unusual argument. The judge then responded firmly and made it clear that the courtroom would not accept claims that ignore established law. The atmosphere grew intense as the judge strongly rejected the man's position and shut down the argument with authority. Many viewers might notice that the man's behavior seems unusual and difficult to understand during the hearing. Something about his attitude and statements feels strange and out of place in such a serious legal setting. Now we will take a closer look at the moment when the judge responds with force and explains why the sovereign citizen argument does not succeed inside a real court of law.
First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir for the people.
Phoebe Muir on behalf of the people.
James Daly on behalf of the defendant.
All right. And we do
I
have.
never asked for an attorney. I said I would be representing myself in appropriate persona. This is just one way to railroad me. That's all. Give me in your jurisdiction.
All right. Mr. Daly, maybe you or Ms. Muir, maybe you can fill me in on the status of the.
Yes, Your Honor. I remember now. We did have an exam in this matter, and Mr. Mattson did represent himself at the preliminary exam. And then Mr. Mattson, then once it was bound over, did fail to appear here in circuit court. So now that he is incarcerated, whereas before he was not, I guess if we just go through whether or not he wants an attorney or still wants to represent himself, since we have had an exam in this matter, once he makes his intentions known on the record, then we can proceed with him still being pro per. But I would like to go through and make sure he is knowingly making that decision.
All right.
I normally am.
Okay. Yeah, Mr. Mattson, just let me sort this out a little bit. Mr. Daly, have you been appointed as standby, or what exactly is your status?
I was appointed as standby, Your Honor. Mr. Mattson and we get along fine. He's a pleasant individual to talk to, but he wants absolutely none of my legal input. Basically, he has a theory that I don't believe is justified under the laws of the state of Michigan.
Okay.
And I've indicated that to him.
All right. We are back on the record then in matter of People versus Robert Mattson. Sir, you are Robert Joseph Mattson, correct?
I am an attorney for the all caps name Robert Joseph Mattson. I am living flesh and blood, human. Upper and lowercase, Robert hyphen Joseph space Mattson. That is my name.
All right.
As shown on my birth certificate, live birth, that would be me, as understood that the government has taken that name and made an all caps name and tried to be to claim an account over that name, which
It is hard to imagine anyone wanting to conduct serious business with this man based on the way he presents himself in court. He struggles to finish a full sentence and often drifts into unclear statements that move far away from the point. His claim of being a sovereign citizen already raises major concerns about how he understands the legal system. Then he begins repeating the familiar claim that his name appears in capital letters and therefore it does not represent his real identity. In reality, the court simply uses capital letters as part of standard legal formatting when documents are filed and recorded. This practice has nothing to do with secret corporations or special immunity from the law. It is simply the normal way official paperwork is organized and stored in the legal system. Despite this explanation, the man continues to act as if he has discovered some hidden rule that places him outside the reach of the court. The situation becomes frustrating to watch because he keeps complicating a process that could have been straightforward and calm. Instead of facing the hearing with clarity, he appears restless and unfocused, which adds to the confusion inside the courtroom. Observers may find his behavior unusual as the hearing continues and the tension slowly builds around the exchange.
All right, sir, do you understand that you have a right to be represented by an attorney in this matter?
I do understand that.
Do you also understand that if you want an attorney and you can't afford one, that you can tell me that and I would appoint one for you at public expense?
UCC 1-308, all rights reserved. By me answering and speaking to you at this time doesn't mean that I'm in any way being given any kind of authority over my body to you at this time.
Okay,
Your Honor.
I will note, sir, your objection to my jurisdiction over you, and I will preserve that for the record. As
Your Honor,
discussed in the hearing on Monday, it is my position that this court does have jurisdiction over you, and I am going to proceed as such. And
yes, sir.
Again, your objection is preserved for the record, and if you would like to file an appeal, if that becomes necessary at a later date, you'll have the ability to do that.
Actually, I think I can do something a little quicker. I like to exercise my rights of subrogation, have the prosecutor file my right to subrogation, or certify my right to subrogation at this time. It's an undeniable right. Subrogation is the removal of a third party. It's in laws, Black Laws Dictionary, 6th edition. Also the Bouvier Law Dictionary, 2nd edition. That the removal of third party would be the prosecutor in this case.
All right. I'll note that request for the record and find that there is no right to subrogation in a criminal matter, and so I'm going to deny that request. Again, your objection will be noted for the record, and if you feel you need to appeal that decision at a later date, you will have the ability to do that. You understand, sir? You understand, sir? That you understand, sir? Sir, please let me speak. Do you understand, as I asked earlier, that if you can't afford an attorney and you want one, that the court would appoint one for you at public expense?
Do not want one. Thank you.
Okay.
I am not a U.S. citizen. I am sovereign. Separated myself from the U.S. government back in 2018.
We've covered that objection, Mr. Matson, and I've ruled on it. Again, it's preserved for the record, and you can appeal it to the Michigan Court of Appeals if you would like to do that.
From a viewer perspective, it almost feels like the judge could take a firmer stance during this exchange. The man who calls himself a sovereign citizen continues speaking as if the courtroom is a casual debate stage rather than a serious legal setting. His speech often sounds unclear, yet he still keeps pushing his arguments forward with surprising confidence. The back and forth continues even though many of his claims have little connection to real legal procedure. It is remarkable to watch how someone can remain so certain while presenting arguments that clearly miss the mark. One idea he repeats again and again is the word subrogation, which he uses as if it can instantly solve the case. In reality, subrogation has a very specific meaning in law, and it usually involves an insurance company recovering money after paying a claim for someone. It is not a powerful legal shield that makes a court case disappear or removes responsibility from a person in front of a judge. Despite this, the man continues to repeat the term as if it will suddenly change the outcome of the hearing. The moment becomes another example of how misunderstanding legal terms can create confusion during an already tense courtroom exchange.
Well, definitely, it's fraud. American jurisprudence guaranteed fraud. I studied it up and down. I know it all too well. So it will go to the Supreme Court. I promise you.
Okay.
As of right now, I would, for the record, and let the record reflect any objections or denials that you keep denying me, that I'm asking you to file a 1090 an OID 1099 for the prosecutor, because the prosecutor is using my name to do business, and I will prepare the 1096 and the 1099A. So this court proceeding is going to go on and have a jury trial. It's going to be sovereign people, secure party creditors at my status, and also you're going to be filing that OID 1099 for the prosecutor.
Right, sir, do you understand that you've been charged with possession of a controlled substance in this case, and that the maximum penalty
I don't
for that
understand the
offense?
nature of the claim.
Sir, I'm going to ask you to let me finish when I'm speaking. I've done the same for you, and I'd ask you to do the same for you.
Your Honor. Yes, sir.
You understand that you've been charged in this case with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, that the maximum penalty for that offense is up to 4 years in prison.
I do not understand the nature and the cause of the crime.
All right, I'm advising you at this point that you have been charged with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, and that the maximum penalty for that offense is up to 4 years in prison. I'm also advising you that you've been charged with operating on a suspended license. A license has been suspended, revoked, or denied, that there is a second offense notice with that, and therefore the maximum penalty for that offense is up to 1 year in jail and or a $1,000 fine. I'm also advising you that you have been charged in this case with alcohol, open container in a vehicle, and the maximum penalty for that offense is up to 90 days in jail. This also carries a habitual offender second offense notice, which increases the potential penalty to 1.5 times the maximum sentence on the primary offense.
Based on the direction this hearing appears to be taking, it seems very possible that this man may be facing a long absence from public view after the case is finished. His body language during the video raises many concerns and strongly suggests that the charges related to controlled substances could be very serious. Even though the hearing takes place through a video call, his expressions and movements are still clearly visible to everyone watching. At several moments, he tightens his jaw repeatedly as if he is chewing something that is not there, which creates a very unusual image during the hearing. His eyes remain wide and restless, and his constant movement makes it look like he cannot stay still for more than a second. He shifts and fidgets continuously as if his mind is racing faster than the conversation taking place in the courtroom. Meanwhile, the judge remains calm and observant while watching the behavior unfold on the screen. The reaction from the bench suggests that this type of situation is not unfamiliar in courtroom proceedings. If the charges include a second offense, the potential penalties could become significantly more serious under the law. The outcome may ultimately depend on how the court evaluates both the evidence and the prior history connected to the case.
As I've indicated, you do have the opportunity to consult with a lawyer if you wanted one, and if you can't afford one, I would appoint one for you at public expense. Mr. Manson, or sir, I believe you've referenced this already, but do you have any training in the law?
Yes, I do.
Would you tell me just a little bit what that training is?
Common law.
Okay, and have you studied that yourself?
Yes, I have, along with a couple other people.
Okay, you understand that the law in this case consists of criminal statutes that you're alleged to violate, the Michigan Court Rules of Criminal Procedure, Michigan Court Rules on Evidence, and any number of decisions from the Michigan Supreme Court and Court of Appeals which interpret those statutes and rules.
I understand that the Michigan Supreme Court offers two different types of courts. Common law court and a tribunal military maritime court, which this court is operating under, and they're not operating properly with me at this time.
Right, you understand that the prosecutor
Sorry, go ahead.
You understand that the prosecutor that's going to try this case has been to law school, has had significant education and a number of years of experience and training in the law?
And that's perfectly fine.
All right. Do you understand that if you do represent yourself, you're going to be required to follow the Michigan court rules and the rules of evidence?
I'm going to be operating under common laws, which that's what I should be under, as common law. This is not a common law court. I don't belong here.
All right. You understand that I know you've made that objection and made it several times, but I'm going to conduct a trial on this matter that's going to require you to follow the Michigan court rules and the Michigan rules of evidence. You understand that?
Yes, sir.
And you understand that those rules are going to determine whether you can do things like ask certain questions of witnesses, admit documents, photographs, or any other evidence that you might have.
Yes, sir.
You understand that you're going to be responsible for the jury selection process, and that's also governed by court rules, which determine when you can appropriately challenge a witness.
Yes, sir.
Do you understand that in order to become a licensed attorney to practice in Michigan, it typically requires at least 3 years of law school and passing a bar exam to show that you have a sufficient knowledge to work as an attorney?
Not a part of the state of Michigan. I am the Republic of Michigan, Michigan Republic.
Okay. Do you understand that in order, if you wanted to have a license to practice law in Michigan, you would need to go to law school and pass the bar exam?
No, incorrect.
It becomes difficult to tell whether this man is carefully avoiding the questions or if he truly believes the story he has created for himself. He responds to nearly every point with another explanation, even when the explanation does not follow clear logic. His confidence never seems to fade, and he speaks as if he has discovered a hidden system within the law that others somehow missed. The way he presents his ideas gives the impression that he believes he has unlocked a secret path through the legal process. Instead of relying on trained legal knowledge, it almost sounds like he followed advice from questionable online sources that promise easy victories in court. Real legal practice requires years of study and professional understanding, which cannot be replaced by a short guide or document found on the internet. In reality, arguments connected to the sovereign citizen movement have never succeeded when tested inside a real courtroom. While some cases may end for unrelated reasons, serious charges like the ones discussed here rarely disappear simply because someone claims special legal status. Despite all of this, the man continues speaking with strong confidence, even though the foundation of his argument does not match how the law actually works. At the very least, his determination remains clear, even if his reasoning moves in the wrong direction.
You understand that the attorneys handling your case, the prosecutor is going to have a license to practice law in Michigan that meets the requirements that I've already indicated to you.
Which makes any judge or prosecutor or attorney a part of Great Britain, foreigners, only operating under their foreign sovereign immunity, which actually I have myself and trumps over all years.
All right. I appreciate your objection to this court's jurisdiction, and I've ruled on that. And again, I'm not going to change the ruling. You can appeal that to the Court of Appeals in the Supreme Court if you wish at the appropriate time.
Do that.
Do you understand that
Definitely.
at least in my opinion, I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself with having a licensed attorney on the other side?
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts. There's nothing fair about it. I mean, you've already made your determination the other day that I was not guilty. Last time I seen you in court. Let the record reflect that. I mean, you sit there and enter the plea and not guilty.
Sir, as I
You already said I was not
indicated,
guilty.
as I indicated to you at that hearing, I entered a not guilty plea for you. That is not my determination that you are not guilty of what's been
It's
alleged.
working from the bench, Your Honor. It's not your job to enter a plea. It's mine or my attorney's, which in this case it would be mine. So the court has already made a determination that I am not guilty.
All right, sir, are you sure that you want to represent yourself knowing all of the disadvantages, or at least what I believe to be the disadvantages that you face?
Yes.
And is that decision absolute and unequivocal?
Absolute and unequivocal.
Do you have any hesitation about the fact that you want to represent?
trial will be my peers. My peers will be secure party creditors.
Do you have any
That's gonna
hesitation?
be the jury.
Do you have any hesitation about the fact that you want to represent yourself?
No. No matter what you do to me, I will get out of it, and there will be lawsuits. And
All right, at
jobs
this
that have been
point-
taken.
At this point, I'm going to determine that Mr. Mattson has made an unequivocal request to represent himself. The right has been asserted knowingly and voluntarily after discussion advising him of the disadvantages of self-representation.
Mr. Daly,
And at this point, I will appoint
will Mr. Daly be willing to come over and talk to me here after we get done with this video screen
All right.
conference?
Yeah, I will appoint Mr. Daly as a standby counsel. And sir, you're
No.
asking,
Can I speak with him about a couple of things?
I can put you in a breakout session so that you can speak to him over video conference privately. If
Let me
you
do
might
that,
need-
please.
Okay.
The moment the pressure from the judge begins to increase, the man suddenly changes direction and says he wants a lawyer. Just minutes earlier, he sounded completely certain that his own arguments were enough to handle the situation alone. Now that the discussion becomes more serious, he quickly abandons those earlier claims and asks for legal help. This shift is often seen in situations where confident statements fade once the legal reality becomes clear. It creates the impression that the courtroom strategy was not as solid as it first appeared. There is also a strong chance that when he speaks with the lawyer, he may continue repeating unusual legal ideas that he gathered from questionable online discussions. Instead of asking practical questions, he may try to explain theories that do not match how the legal system actually operates. For the attorney assigned to the case, this situation may become very challenging as they attempt to guide the conversation back toward real legal procedure. The lawyer's expression suggests a long and exhausting process may lie ahead. Even the judge appears patient, but clearly aware that the hearing has taken an unusual turn that could require much more time and effort before it is resolved.
Mr. Mattson should be back from the breakout session shortly.
Your Honor, I'm going to be going over and talking to Mr. Mattson. I still think, after my discussion with him, there may be some ways to work this out.
Okay. He should be back from the breakout session any second here.
They're back on.
All right, we do have Mr. Mattson back from the breakout session with Mr. Daly at this point. Mr. Daly, you had indicated to me off the record that you were going to have an in-person meeting with Mr. Mattson at this point. Is that correct?
I will. I can't get that done till Monday, but I've already indicated to him I'll do it on Monday.
Okay, and sir, is that something that you want to do, is have an in-person meeting with Mr. Daly?
Yeah, I want to see if there's something that we can work out here just to save time and hassle and a lot of grief between all of us.
Okay,
But I really would like to speak to Mr. Daly one last time before.
all right. Okay, so this is an arraignment. I presume, Mr. Mattson, that you'd like to enter a not guilty plea until you've had an opportunity to speak with Mr. Daly. Is that correct?
Yeah, I'm not entering any plea until I speak with Mr. Daly and he
Okay.
speaks with the prosecutor.
Based on that, I'm going to find that Mr. Mattson stood mute to the charge, and I'll enter a not guilty plea on his behalf. And I'll set this then for a pretrial.
I object to that, Judge. You cannot enter, that's working from the bench, you cannot enter a not guilty plea on my behalf. Either me or my attorney has to do that. I mean, has the court again made a determination that I'm not guilty?
All right, as I've explained previously, it's not a determination that you're not guilty. It is an entry of a plea based upon your not entering a plea at the arraignment. I will set a pretrial for December 1st at 8 a.m. and that will give time for Mr. Daly to have an in-person meeting with you at the jail.
Can I speak with Mr. Daly here again in private?
I'll just go over to the jail and see him on Monday, Judge.
Okay, he's going to come over to the jail and see you in person on Monday. So you can tell the officer that's with you that you're done in court for today.
Okay, how about next time a bond, PR bond, next time I go to court? All right.
With respect to the bond for right now, I'm going to leave it as it's currently set based on prior failure to appear at an arraignment.
I did appear. You wasn't there. I went to the clerk's office. Then I went on the television screen for Anna Marie's court. And it kept clicking me off for about 45 minutes. And after that, I gave up. I did appear. I think that's a due process thing.